This attorney is really starting to piss me off, you guys. They are being so fucking shady with this bullshit. And I now see why. What's going on, chat? I now see why. You're not gonna believe what his response was for my motion to reconsider. You guys are not gonna believe what the response was. It's complete and utter bullshit. And they know it. They know it. So I'm gonna show you guys what he fucking said. Tap the screen, guys, tap the screen. I'm gonna show you guys how fucking corrupt this goddamn city is. I'm gonna show you what he's trying to do in court right now. What he's trying to say in court. I'm gonna show you just how fucking corrupt this city is. Okay? By the way, the contents in this video are strictly my opinion. They're not intended to hurt anyone, cause any malice, or any issues within the public or public interest. This matters of this video is restrictively for case purposes only, a matter in which I'm currently dealing with. If you are screen recording, you are being asked to stop immediately. This case is not entirely public, and anyone who live streams and records this video without my consent will be reported, and you'll hear from me. So please do not screen record this. This is not permitted. I'm not consenting to screen recording this live streaming at any time. All right. So you guys know I filed my amended emergency motion to reconsider and dissolve the preliminary injunction that was filed. Literally filed. I have the case when it was filed. I'm going to show you guys the case paperwork. Okay. Just so you guys know, the mountain of evidence that I have is right here. All right. The mountain of fucking evidence that I have to support my case on Monday is literally right here. Okay. So let's go through it, shall we? Because this guy is about to piss me the hell off. Okay. This was the motion that was filed. After the motion was filed, a new hearing was scheduled. Oh, look at that. It was scheduled at 10 a.m. because they knew the library opens at 10, and if the attorney responds, I'm not going to have enough time to type up my response and submit it to court. They fucking know this shit. They know this shit, okay? So they're playing the system very well. The judge is even playing the system with them. Like, she doesn't want a part of this case. Like, I don't know why she doesn't just recurse herself from the fucking case. It's ridiculous at this point. So I wrote this up and realized, I wanted to redo it. I had some additional information that was, submitted. Obviously, when a FOIA request goes into place, things take a little extra time. Okay? So I redid my amended emergency motion to reconsider and to dissolve the stay. Sure, whatever, recuse. So after I did all of this, right, I submitted supporting documentation. That's what I'm going to call it. Not an exhibit, but supporting documentation, which is this. You guys heard this over the weekend. This is, I don't feel good. I've been sneezing and I know I'm getting sick. So this is basically to meet the RLUIPA strict scrutiny standards that I've already proven without a reasonable doubt that were true and factual and evidential, and you guys already know this case is now going gray water. You know why? Because both sides are arguing the dumbest fucking things. Okay, this is a gray water case because what's happening is the attorney is now trying to say, oh no, Mr. Hayes, you can't submit new evidence after an evidentiary hearing. You had that option. No, I had 30 days to respond to this injunction. And now he's trying to argue that I don't even have a reason to, he's trying to argue I have no reason for actually filing it, which is the like, it's ridiculous how at great lengths this guy goes. So bear with me. I'm going to go ahead and grab that file real quick. And I want to read to you guys what the fuck he said. It's completely brainwashed, you guys. This guy is completely brainwashed. And I swear to God, I cross-referenced everything that he said. It's complete fucking bullshit. Okay? He's taking context from court cases to literally, he's taking context from court cases to literally manipulate the judge. And I'm going to show you exactly what he says in the response that I ran through. It's a 10 out of 10 when it comes to true findings. So bear with me. This is his response that he just emailed to me about the first thing he's actually done that's legal so far. Because quite frankly, all of the e-filings are garbage. The system doesn't even work. I've been locked out of the e-filing system, so I don't even have an option to actually e-file. Okay, this is what he says. We're going to ignore the introduction. Well, you know what? We're going to read the introduction. Plaintiff filed a complaint on June 29th, 2026, seeking an injunction from this court, seeking to enjoin defendant from living and occupying in the structures, blah, 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 blah. On July 13th, a hearing was scheduled for the plaintiff's petition for a preliminary injunction. On that date, the hearing was continued to provide defendant an opportunity to respond to the plaintiff's petition, in particular to plaintiff's citation, which is Roxana Community Unit School District, blah, 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 which provide that a municipality enforcing its ordinance do not have to prove irreparable harm or an inadequate remedy at law. And further, there is no balancing of the interests. First of all, I don't know what in God's name he's referring to, because when you read that, that's totally not true. Because that is a departure from the traditional elements for a preliminary injunction. No, it is not. Somebody can file a motion to reconsider in any injunction. So I'm not sure what the hell he's like referring to there. But anyways, defendant was given an opportunity to, quote, supplement his response to the petition for preliminary injunction. Excuse me, I gave you my response in open court. That was my response. I didn't refuse an opportunity to respond. Defendant chose not to supplement. Oh, really? Did those words ever come out of my mouth? No, they did not. On July 22nd, a hearing was held on the plaintiff's petition for preliminary injunction. Evidence, false evidence that was tampered. Okay, you literally see him giving paperwork to the witnesses so that they can recollect their memory, refresh their memory, which is the most unbelievable things that I've ever seen in open court. Okay. Evidence was presented by both parties in the form of a testimony and documentation. No. Some evidence. I couldn't call upon witnesses because you said that you were excluding witnesses. At the conclusion of the hearing, arguments of the parties were presented. The court granted plaintiff's petition for a preliminary injunction enjoining the defendant from living and occupying and otherwise using the structures on the property at 1705 East Carpenter during the duration of the order. See the data, blah, 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 blah. The legal standard. The purpose of a motion to reconsider is to bring the court's attention newly discovered evidence that was not available at the time of the original hearing, changes in existing law, or errors in the court's application of the law. Vantage Hospitality Group. Now, this is just him showing off because you don't even have to include this part. Okay, we get it. We know that part. I've already included that in my own motion. In fact, let me show you. Okay, my reason for that on my introduction is the exact same thing. Okay, on blank, 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 blank. You see what he's doing? He's mimicking the way that I'm using my own introduction to argue my own case, bro. Okay? Look at this. Newly presented documentary evidence. What does it say? Okay, it's literally fucking hilarious. Okay? On or about July 23rd, 2026, the court granted the city's request for preliminary injunction. What does he say? On July 22nd, 2026, a hearing was held on the for preliminary injunction. You have got to be fucking kidding me, bro. This guy is literally trying to use my words against me for my motion that I fucking filed. Like, that is insane. I've never even seen that before, but I'm going to use that against him in the future. Just watch. Okay. He states this crap that you don't even have to read through because we already know it's law. Defendant has not specified the basis for the motion to consider. Oh, really? Did I not underline it for you? I'm pretty sure I did. The legal standard for reconsideration. A motion to reconsider is appropriate to bring to the court's attention newly discovered evidence, changes in the law, or errors in the court's application of existing law. And what does he say? The purpose of a motion is to reconsider, to bring the court's attention newly discovered evidence that was not available at the time of the original hearing. We're not going to call it evidential, thanks. Changes in existing law, or errors in the court's application of the law. Application of the law? Application of the law. It's existing law. Application of existing law. C. Gardner versus Navistar. Blah, 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 blah. This court has broad discretion to reconsider interlocutory orders, including preliminary injunctions, prior to final judgment. The Heartland House ordinances and agreement constitute as newly presented evidence that was not before the court when the injunction issued. And that conclusively establishes the federal jurisdiction to predicate the RLUIPA. Okay. So let's go ahead and go back. Defendant has not specified the basis for the motion to reconsider. I literally did, but you didn't fucking read it. Didn't want to put it in there. But it appears defendant is arguing an error in application in the court's application of law because defendant does not present any evidence in his motion and does not argue a change in the law. It's not, Your Honor, it is already law. It's already law. It's not a change in the law. It's already fucking law. It's been law. Okay. And this is his fucking argument. A defendant's motion should be denied for raising new arguments not previously argued. No, it's not a new argument. It's been argued. The whole video literally says it in my testimony that this tiny pod is for religious use. It is not proper to raise new arguments in a motion to reconsider. It is not proper to raise new arguments. It's not an argument. It's new evidence. It's new evidence supporting my defense. North River Insurance, blah, 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 blah. So he's citing case law. The trial courts should not allow litigants to stand mute, lose a motion, and then frantically gather evidentiary material to show that the court erred in ruling. Yeah, but it's an error because you didn't include the legal standard in which I had tried to provide. Likewise, this court should not allow the defendant to stand mute, lose a hearing, then after the fact raise new legal theory. It's not legal theory, it's already law, for while he should have won. It's already fucking law. and you overstepped your bounds. The court should have gave adequate time for reconsideration, should have even said, hey, you can file a motion for reconsideration if you disagree. But in the entirety of that hearing, there was no mention of that either. So what the fuck are you talking about? Defendant had his opportunity to respond in writing previously and to make these arguments, but chose not to. Can you specify when? We had 4 hours of evidential hearing debate. You're telling me I had an opportunity to go into case law and review it within a matter of what, 2 minutes before the case was up for 30 days? What is he talking about? Literally makes no sense. For this reason alone, defendant's motion should be denied. So because you're saying just because I had time to respond, it should be denied? No, I didn't. I had 30 days to respond. And I'm not making an argument. I'm showing you missed evidence. Even on the merits, defendants, I can't with this guy, even on the merits. So they're agreeing that I have permissible purpose to actually file the motion for reconsideration. Even if this court considers, it's not going to consider, it has to, the merits of the defendant's motion, the motion should be denied. Denied, denied, denied. Denied, denied, denied. Y'all, this is crazy. Defendants argue that the Religious Land Use and Institutionalized Persons Act of 2000, RLUIPA, controls here and necessitates this court to make a different decision, yes, and vacate the preliminary injunction. However, defendant is wrong in his interpretation for 2 reasons. Oh, please, I'd love to hear this. First, defendant has not established that he has met the burden under RLIUPA. Really? Let's go back to mine. Number 1, my argument. The preliminary injunction imposes a substantial burden on the defendant's religious exercise in violation. It's a violation of the RLUIPA. That's the argument, that you violated this law by issuing an injunction, and that my support for the violation is that the RLUIPA prohibits any government from imposing or implementing a land use regulation in a manner that substantially burdens religious exercise, unless the government proves the burden, 1, further a compelling governmental interest, and 2, the least restrictive means of doing so. 42 United States Code. This protection applies to individuals, not only institutions. Religious exercise is a broad definition. Defendants' sincerely held religious beliefs, the Celestican Church of Christ, include living off-grid in a faith-based tiny home/pod structure as a form of worship. Self-sufficiency and separation from certain church-state entanglements. The RLUIPA broadly defines religious exercise to include the use of real property for religious purposes, regardless of whether the practice is central or compelled by doctrine. So I don't have to document anything. Substantial burden. The injunction forces the defendant to abandon his religious practice or face eviction and homelessness. This renders his exercise effectively impracticable on his own property. See the Civil Liberties for Union Believers versus Chicago, 342. And so on. The city's own records, detailed below, demonstrate that it simultaneously funds programs expressly designed to prevent and end homelessness, yet seeks, what I'm going to say, a reckless order that would create the very condition these programs exist to eliminate. The RLUIPA injunction is conclusively established by the city's own ordinances and agreement, with Heartland Housed, which is Allied Heartland Housed, but whatever. RLUIPA applies to any land use regulation that is imposed in a program or activity that receives federal financial assistance. I proved it. And number one, an ordinance that was passed in 379-08-23 on August 15th, 2023, and subsequent addenda. All of this money was given to this program. Let's go on even further. It shows all of that funding, okay? The city has not met. Actually, let me go back. These documents are public records of the city itself. They establish as a matter of law that the city participates in and administers programs that receive financial assistance. Consistently, any land use regulation the city imposes, including the injunction and underlying code enforcement actions, is subject to the RLUIPA's strict scrutiny standards. Illinois Industrial Services, LLC, do not and cannot override federal protections under the Supremacy Clause. This is a Supremacy Clause. The order's exclusion of hardship must be reconsidered in light of these federal requirements, which are now documented beyond dispute. Whether they were documented, guys, before or during or after court, it does not change. Thank you, Shaby. It does not fucking change factual federal protections and law. And so what is he saying? The structure's minimal impact. Defendants does not rely on the city's utilities because I have my own. And the defendant's SNAP-supported self-sufficiency further weigh against the total prohibition. The city cannot simultaneously claim a compelling need to force me into homelessness while sending hundreds of thousands of dollars annually to prevent and end homelessness. The least restrictive means inquiry fails as a matter of law. Requires stricter scrutiny. See Employment Div versus Smith. Blah, blah, blah. Faith-based living arrangement raises equal protection and due process concerns under the 14th Amendment on top of the first. The city's documented commitment to addressing homelessness through federally supported programs while pursuing an order that would render the defendant homeless underscores an arbitrary character of the enforcement. Literally. So let me go back and read his bullshit. So I want you guys to see this crap. The defendant has not met his burden of showing the city's code substantially burdens his religious practice. Have I not? It's right fucking there. Your code violates my civil rights. A party asserting a RLUI claim bears the initial burden of proving that the land use regulation substantially burdens their religion exercise. Thanks for putting case law in there. In order to prevail on a claim under the substantial burden provision, a plaintiff must first demonstrate that the regulation at issue actually imposes a substantial burden on religious exercise. Oh, really? I think I've already done that. Balance of equities and irreparable harm to the defendant. Defendant faces immediate irreparable harm, loss of housing, interference with religious practice, and potential loss of benefits, which is under RLUIPA. The city faces no comparable immediate harm to the public, especially given the property's private location. It's already been sent to the news. It's going to be covered on Monday, so don't worry. Equity favors the solution over stay. Moreover, the city's own expenditure of public funds to combat homelessness makes it inequitable for the city to insist on creating new instances of homelessness through its injunction. Blah, blah, blah. But there is a section in here where I specifically talk about it, so give me 1 second. I specifically talk about, there we go. I'm not even required to do that, actually. So you know what? I'm not required to do that. I'm going to go on to the next. We therefore hold that the context of the RLUIPA's broad definition, it's not broad, dumbass, it's right there, of religious exercise, a land use regulation that imposes, thank you, Deborah, that imposes a substantial burden on religious exercise is one that necessarily bears direct, primary, and fundamental responsibility for rendering religious exercise, including the use of real property for the purpose, therefore, within the regulated jurisdiction, generally, effectively, impracticable. The Seventh Circuit defined substantial burden as a land use regulation that imposes substantial burden on religious exercise is one that necessarily bears direct primary and fundamental responsibility for rendering religious exercise, including the real property, the purpose of their blah, 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 blah. It is well established that there is no substantial burden placed on an individual's free exercise of religion, where a law or policy merely operates so as to make the practice beliefs more expensive, blah, 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 blah. The City of Chicago's zoning ordinances, which were facially neutral and placed limitations on where certain structures could be located, were not substantial burdens under the RLUIPA, even though the zoning ordinances did have an impact. Yeah, okay. This is not talking about where we're placing the goddamn building. This is us saying the building is already there and I want to practice my religion on my own property. Here, the defendant has not established that exercise of his faith is substantially burdened. Really? I'm pretty sure I mentioned that. Defendant has been vague and elusive about his religious beliefs are. I don't have to tell you what my religious beliefs are. I don't have to tell you shit. If his religious beliefs, this is an if now, way to go. If his religious beliefs are to practice his faith on his own property, the court's order does not restrict defendant from doing so. Yes, it does, because in my actual testimony where I specifically said a Celestican's job is to live minimally peacefully in his or own house, to live in a small structure as a part of worship. So explain to me where you think that's not the case. Let me go back to my reconsideration. We're going to come back to that. I'm going to show you guys. I'm going to come back to case law here in a minute. My response in a minute. If his religion dictates that he cook outside the structure or live a minimalist lifestyle, then the court's order does not substantially burden his religious practice. Because of this vagueness, and lack of specificity, I got a 7-chapter book I'm literally going to print and fucking submit as evidence, which he's going to argue and say, "Objection, Your Honor. We already had an evidentiary hearing." I don't give a shit what evidence I can submit. I am legally allowed to submit it at any fucking time, especially during this reconsideration. Thank you, Imore. Defendant has failed to meet the burden. Thus, defendant's motion should be denied. I have not failed to meet the fucking burden. Watch the video. It's in court transcript. It's in court's literal transcript that living in the pod is a part of my worship. It's a part of my faith. And this is the best part. Even if the court finds that the defendant has met his burden, plaintiff has a compelling government interest in maintaining order and safety for occupants in houses. Objection, Your Honor. How does my religion affect public safety? This is a private fucking property. How does me living in my house interfere with somebody's life and safety on my property? This is private property. It is not the objection of the city to sit there and say, "No, Mr. Lexus, you can't practice your faith in your own home on your own private property because we have an obligation to keep the public safe." Excuse me? Excuse me? You are full of shit, dude. And then he goes, "We do not read RLUIPA to elevate accommodations." Accommodations? You're required under federal fucking law of religious observances over an institution's need to maintain order and safety. The city was incorporated after federal law took place, Your Honor, and the city's required to follow federal law. And then, of course, he goes and throws this bullshit in. The First Amendment gives no one the right to insist that in pursuit of their own interests, it's not interest, it's faith, others must conform to their conduct to his own religious necessities. I'm not forcing anyone to conform to my religion. It is happening on my property. It is on my property in my own home. So this does not apply. The Seventh Court, I love how he didn't fucking number this. He was supposed to number every single line so I could actually argue it in court, but he didn't fucking do that, so I'm going to have to do that for him. The Seventh Circuit Court held that a government has a compelling government interest in preserving the single-family residence limitations of a zoning district. I'm a single male. There's no family applied here. I live single. I'm single. I have no pets. And it's just me. The property is in my name. It's in my fucking name. Paid for. No taxes due. This is not a single family residence. There's 2 units on the actual lot. And a residence has already been established. We've already established a residency, a voter registration card, which, by the way, also is being impacted because if I can't live there, Your Honor, I can't fucking vote. And I bet your ass Trump will be involved in that. The Seventh Circuit Court has held that a governmental, compelling bullshit interest in the preserving the single family bullshit. It's literally complete bullshit, you guys. The courts held that the RLUIPA is meant to protect religious freedoms from impermissible land use regulations. Correct. Wow, we actually agree on something. It is not meant to allow religious exercise to circumvent facially neutral zoning regulations. It is not neutral. It is not neutral. Because prior to the zoning code, which you also had new enforcement applied against tiny homes. If a church was under 400 square feet, Your Honor, then what the fuck? You're saying that those people can't go to that church because the building itself does not meet building code. And because it doesn't meet building code to an inspector, suddenly that building is rendered unsafe? No. The city code still permits a building at 118 square feet, which doesn't need a permit. Anything over 120 square feet. But this is an accessory dwelling. It is not an accessory dwelling because the primary residency has already been established on the property for longer than 90 days. Oh, but you don't have a primary dwelling. I do. It doesn't meet your size. It meets my size because my size is based on religious use. I am not required to build a home over 400 square feet. Well, your ward requires it. No, my ward does not. The memorandum is only in effect for 2 years. So you're saying you would rather impede my rights to practice my freedom and my religion for 2 years because you have a mematorium? Your mematorium is breaking federal law. And this is the best part. Here, the city is seeking to enforce facially neutral codes for its zoning ordinances. Ordinances are not fucking law. It's building code. No, I'm self-representing, Irene. I'm self-representing, and I'm gonna argue this one in court. And I swear to God, she needs to reconsider, or we need to start calling the courthouse and asking for her immediate resignation. City wants only clearly established resident structures in its residential area. City wants only clearly established residential structures. My structure has already been established. It was made in Chicago. It was moved to Springfield, and then it stayed in Springfield for longer than 30 days. After residency was established, I filed for the right to vote. That's what makes it established. Additionally, my driver's license, my CDL driver's license, currently states the address of issued date. If you take that date from the date of the injunction that was granted, you're going to see a wide lateral, and that's longer than 30 days, applicable to federal and state law. All right, we're going to get to his ridiculous conclusion. Defendant's motion should be denied because he is raising new arguments. It's an absolute fact that this has been previous law for the first time after standing mute and leaving an adverse order entered. It is not an adverse order. This is a preliminary injunction. This case is not concluded. And it's not something I've made for the first time. It was brought up in the hearing. If I get court transcripts, I will literally show you where I specifically said that the structure is being used for religious purposes. It was in my response when it was filed. So let me take a look at the response. Okay. Plaintiff's response, defendant's motion stay. Hold on, let me grab the original response that was filed. Thank you guys. We're gonna dig into this shit. Today I'm gonna file this. I'm waiting for my friend to pick me up. But I'm gonna show you guys what my argument was to the court for a stay. I requested a stay and that was denied. And he argued that the stay was not related to the cases. Yes, they were. The federal case has the same plaintiff and the defendant in the same case. He said they were not related. Yes, they were. The whole reason for the civil rights violation that was filed federally is because they're impeding on my right to practice my faith in my property on my own. So, give me 1 second. I'm gonna grab the I know it's in here somewhere. I gotta find my original. There we go. Oh, what's this? Emergency motion to vacate proceedings and for immediate stay pending related state federal agitation. Okay, sweet. Let's go ahead and fucking read that. You're telling me I didn't submit, that this was not included? Okay, here's my legal argument. Illinois courts possess inherent authority to vacate orders entered through irregular proceedings and to protect the integrity of judicial proceedings. Number 17, Illinois courts likewise possess inherent authority to stay proceedings in the interest of justice, judicial economy, and avoidance of inconsistent rulings. The Due Process Clause, which was violated, of the 14th Amendment of the United States Constitution guarantees fundamentally fair proceedings before deprivation of protected fucking rights. Number 18 is the reason why the court should have literally issued a stay, but she completely ignored that. Article 1, Section 2 of the Illinois Constitution similarly guarantees due process of law. 20. Defendant contends that the conducting parallel proceedings, because they are parallel, both of these cases are talking about the same fucking thing. They're getting sued for violating my right to worship in my home. Similarly, in this hearing, Your Honor, this is why I'm asking for reconsideration. Defendant contends that conducting parallel proceedings concerning the same controversy before an administrative Tribunal, while related judicial proceedings are pending, undermines the judicial administration and risks inconsistent factual determinations. 21. Defendant further contends that receiving evidence contrary to an existing court directive would literally interfere with this court's authority to control proceedings before it. Before a federal rights action concerning substantially related evidence has now been filed, judicial economy and avoidance of inconsistent judgments favor staying or otherwise vacating further proceedings. But there's gonna be some verbiage in here. There's gonna be some verbiage in this one. If it's not in this one, it's gonna be in the. There we go. There we go. Let's go. This should be. No. Hold on, guys. No. So it's in my additional response. Give me 1 second, guys. I actually think it's in his response for why I shouldn't have had the stay. So let me hold on, guys. I gotta find my original argument here, guys. I'm literally looking through all this fucking bullshit for this crap. Thank you for the likes. If I go back to the emergency motion, let me look at the emergency motion. It's probably on the computer. It's probably I'm not seeing it. Substantial burden. The injunction forces the defendant to abandon his religious practice or face eviction and homelessness. This renders his exercise effectively impracticable on his own property. See Civil Liberties for Urban Believers versus City of Chicago. Okay. Somewhere in here it's going to say Celestican, but I believe it's... Okay, let me organize these real quick, guys. Because I know it's in here. Okay. I heard your story, thank you. This is the food assistance. Okay. This proves that I received food assistance throughout June when it was finally agreed upon. Okay. This shows that the residency has been established. It literally says residency there. Okay. For those of you wondering about the voter registration, because I know that came up in conversation, I saw it in comments, so let me bring that up. Hold on, guys. It was already entered as evidence, so I'm not worried about it. Okay. Oh, there we go. It was in the original argument right there. The preliminary injunction imposes a substantial burden on the defendant's religious exercise in violation of the RLUIPA. RLUIPA prohibits any government from imposing or implementing a land use regulation in a manner that substantially burdens religious exercise unless the government proves blah, 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 blah. Religious exercise. The defendant's sincerely held religious beliefs Celestial Church of Jesus Christ include living off-grid in a faith-based tiny home/pod structure as a form of worship. I'm still going to say it in court so that there's a transcript of it, but whatever. Sufficiency and separation from certain church-state entanglements. RLUIPA broadly defines religious exercise to include the use of real property for religious purposes, regardless of whether the practice is central or compelled in doctrine. Substantial burden. The injunction forces defendant to abandon his religious practice or face eviction/homelessness. It really should say and. This renders his exercise effectively impracticable on his own property. RLUIPA jurisdiction is satisfied, including by federal funding, because they receive federal fucking funding. And you know how I know? Because when this was filed, after it was amended, we included the evidence that they receive funding. Okay? It's part of HUD. This is public record. It shows in my submission this information. And if I didn't say see exhibit, I'll be extremely surprised. So let me take a look here. Newly presented documentary evidence, official City of Springfield ordinances, and the agreement with Heartland House establishes beyond dispute that the city receives and administers federal financial assistance for housing and homelessness programs, including explicit mandates of the U.S. Department of Housing and Urban Development, also known as HUD. This evidence confirms RLUIPA's jurisdiction as a matter of law, demonstrates the city's simultaneous expenditure of public funds to address homelessness while seeking to render the defendant homeless, and proves that the less restrictive alternatives exist. You got to be completely out of your mind if they're trying to say that, oh, we're required to uphold public safety and all this extra bullshit, but this is happening on private property where it is not hooked up to public utilities. Can you explain to me how my private property can impact the public? I want to know how my public property can impact the public. Can you show evidence that it being there currently impacts the public? Can you show evidence that my actual structure will interfere with the rights and liberties of other people? I thought so. Let's go on to his closing bullshit. Conclusion. Defendant's motion should be denied because he is raising new arguments for the first time after standing mute and having an adverse order entered. Further, it's a preliminary injunction, dumbass. Further, defendant's motion should be denied on the merits because he has not established that the city's ordinances are a substantial burden, and even if so, the city has a compelling government interest. Your compelling government interest doesn't fucking apply because you've violated federal law. Now comes the defendant, Chase Hayes, aka Colton Lexus, standing in pro se. Okay, I've already filed this, you guys. The substantial burden enforces the defendant to abandon his religious practice or face eviction and homelessness. Well, enter this into Exhibit 1. Give me 1 second. You know what? I'm going to save it for the hearing. I have the paperwork here, but I'm going to save it for the hearing. Okay, because I don't want to give everything away. This is what was ordered by the judge. Let's go ahead and go to it. The orders as follows. By the way, he typed this up and she just fucking signed it. The plaintiff's petition for preliminary injunction is granted. Defendant is enjoined and restrained from living in, occupying, or otherwise using the structures at 1705 East Carpenter. You said so yourself. I cannot live, occupy, or use the structure. You literally said it in there. I cannot live in, I cannot occupy, or use the structure. That violates my civil fucking rights. Defendant is further enjoined from allowing any other person to live in, occupy, or use. So if another person who is a Celestican wants to worship the same way in my house, you are effectively rendering their religion inoperable as well. And then they have some extra bullshit. Your order specifically states that I cannot use the structure for religious use, when my faith is telling me that I can. When federal law says that I can. In this case, needs to be dismissed at its entirety. Not only can I not use the structure, I can no longer legally vote because I no longer live at that address where I am registered to vote. So that's a violation of my right to vote. It's not new evidence. It was presented to you in court. So this is where we're at, you guys. This is where we're at. They're trying to say, that their building codes supersede federal law. Let me show you the evidence that was entered. Exhibit A, ownership of the property. Okay. $3,495 went to purchase the said property. It shows heating. It shows access to utilities. It shows a working light, an emergency exit. It shows garbage removal. It shows that it has integrated security systems in it, a smoke alarm that has a battery for 10 years in the room that's being occupied. Oh, look at that, an illuminated light. Literally shows utilities. A window that can open literally shows emergency exits. A door with a security camera literally shows security. Solar panels. Okay. It has a sign that says no trespassing, so the public won't be interfering. The fire extinguisher. We've got the safety kit, carbon monoxide sensors. We got the guy who installed the security system. We have the damage to religious property, which they're getting sued for. We have a working fan. We have a microwave. We have the police report from when the damage was done. We have photocopies in case anyone is colorblind. Okay, we're going to get to the next one. It's not done yet. We got tons of evidence. We have good faith effort of when I requested to have water installed. It was on May 4th, 2026. No violation occurred. Good effort was made to get water in the property. They refused to do it. Okay, it says, these are their arguments for why I can't live there, okay? They're saying this structure has no utilities, including electric, water, and sewer. I showed electric, I showed water, I showed that there was heat. Oh wait, how does a heater work if it doesn't have electric? Right, okay, bottled water outside of the structure. Then they're talking about waste disposal, utilities, health, and safety. Okay. I showed that I have been practicing my religion since I was a child. Okay, that's a picture of me when I was a kid. Building a tiny house. I've showed I have been living in there and receiving services. I showed that I was registered to fucking vote. And it says, "Dear voter, our office has been notified by the State Board of Elections of a change of your voter registration address in Sangamon County. By law, the election office is required to automatically register you to vote at this new address. I'm registered to vote. Only complete and return this letter if the enclosed voter ID card does not reflect your current address." I'm staying here until tomorrow night, you guys. Tomorrow morning. Okay. For those of you that don't know, I showed that I was previously homeless. This is a letter to which it says, this letter is to verify that I've been homeless and that I've been homeless since 1/1 of 2020. Okay, here's the voter registration card. I'm telling you guys, these people are full of shit. These people are literally full of fucking shit. So, oh, and for those of you that are like, oh, why doesn't he just go to a food bank? Why doesn't he just get a job? Why doesn't he this? Why doesn't he that? Oh, really? Really? Watch this. There goes the summer meals directory that I looked at. Are any of them nearby? Nope, they're not. There goes the find food resource. Are any of them nearby? Nope, they're not. This is the other shit that I was given. I've looked at that. Food pantries and meals. Are any of them nearby? Nope, they're not. So for all of you that are like, oh, well, you should this or you should that. You know, I've done that, you guys. I gave them 3 days to issue the building permit, and they refused to do it. This is the letter that they were given. You guys can screenshot it. Okay. This is me requesting a Freedom of Information Act for emails to them so they can prove that I made good effort. This is them pretending to be a judge before a code hearing officer, not a judge. Okay? This is them tampering with my due process. Okay? So guys, this whole thing is completely insane. So you guys probably didn't see the video where I said why the judge should grant my my reasons for it, okay? This was my response. This was my response in evidence. Watch this. They're saying, right? They're saying that I'm trying to enter new arguments, right? Let's go back to his response. Here, defendant has not established the exercise of faith, blah, blah, blah. Okay, let's go back to where it says I'm trying to raise new arguments. The conclusion, defendant's motion should be denied because he is raising new arguments for the first time after standing mute. All right. This was filed the day of the court date. Okay, this was the original response. Defendant's response in opposition to plaintiff's petition for preliminary injunction. That was the filing. They filed it and I responded to it. This was my response. It was the day of the hearing, okay? The first day of the hearing. The matter concerns the defendant's use of property located at 1705 East Carpenter Street, Springfield, Illinois. Number 2, defendant has placed and occupies a personal owner-built dwelling, otherwise known as POD, a small, modular, residential structure upon the property the defendant lawfully owns, Exhibit A. Number 3, plaintiff seeks a preliminary injunction prohibiting the defendant from residing in the POD. Defendant denies that the plaintiff has established the legal requirements necessary for the issuance of such extraordinary and unjust relief. The factual background. This is the argument, technically. Number 4. Defendant constructed the pod as his only primary residence. The defendant receives mail, packages, donations, garbage disposal services via Republic Services Incorporated every Thursday, Exhibit H, and obtains food assistance through state-funded food stamps, namely EBT. See Exhibit I. The pod is equipped with multiple safety features, including a fire extinguisher, smoke alarm, carbon monoxide detector, and Vivint security monitoring and surveillance. Exhibit B, C, D, E. The pod also includes an alarm system capable of providing fire alerts, panic notifications, and emergency police assistance. Number 6. Number 7. Defendant has access to a microwave and portable dishwasher that is powered by a 3,000-watt generator. Exhibit F. The defendant also has solar-powered, which is the home, 300-watt solar panels. Exhibit 7. Number 8. Defendant prepares meals outdoor as part of his daily routine and as an expression of his sincerely held belief, as expressed publicly via news article Man Fights City Hall by Adrian Dater, dated June 26, I am a Celestican. And there's your article. Ooh, my favorite part. The religious freedom where they're saying I'm trying to enter new evidence or argue new something that I'm arguing new something. Okay, I'm pretty sure that's the reason for the reconsideration, because you totally ignored the religious version of that. You're talking strictly about city code, city ordinance. You've completely ignored this. Defendant disputes plaintiff's allegations that the pod presents unsafe conditions and asserts that he has made good faith efforts toward compliance with applicable requirements, applied for a permit, but was denied. Oh, that's right. We have a copy of that. We showed that. Just in case you missed it, let me show you again. It's not unsafe, you guys. Are full of shit. They're full of shit. If I did a home inspection for anything that would be unsafe, they would say your home is safer than anybody here. The fucking roof has hurricane ties. Give me a break. Give me a fucking break. So, you guys want the originals? Here we go. What's the date on that? Department agents provided false and misleading information regarding a shed structure, said that additional permits were required rather than verification of city ordinance, shows that the shed does not need permitting due to its square footage of 32 square feet. Additionally, staff refused to answer questions and provided basically false details to management. You are 3-day notice. You are hereby notified. You have 3 days to issue or deny the permit. Request dated 6/16. If you deny the permit, will continue on 1705 East Carpenter Street. You were given. There is a bathroom, Wyatt. There is a bathroom. So, they were given adequate time. Let's continue. They're saying I'm trying to enter new evidence or have a new argument. It's absolutely not true. This was presented on the first day of the hearing. These are the arguments. Religious freedom. I should have just called it basis for argument. Defendant is a practitioner of a Celestican, a sincerely held belief system centered upon celestial harmony with Christ, personal, spiritual anatomy, connection with nature, and integrating daily living, including outdoor cooking, and residing within a personally constructed dwelling as acts of worship. Number 11, defendant publicly affirmed these religious beliefs through published press release videos. Number 12, defendant asserts that residing within the pod and engaging in outdoor cooking, notice within the pod and outdoor cooking, are integral components of the sincere exercise of his religion. Okay? So, yes, there is running water, guys. Who wants to see the running water? I will show you the video for running water. Let's go to let's go look it up. Let's go look it up. We're gonna grab it. We're gonna grab it. Let's take a look, shall we? And it was on before the injunction was issued. Okay, so we had evidence. We showed the judge all of this, by the way. Oh, look, there's a picture of me exercising my faith as a child.
Sometimes.
Huh, that's amazing. I have that picture. Submitted that into evidence. Oh, look, here's the running water.
Colton Lexus, in today's video, I'm going to show you guys an off-grid water pump that I built using a mailbox, 7-gallon water jug with filtered water, and this inlet-outlet hose system that I got set up. So what can this be used for? Well, the city of Springfield claims I don't have running water. So, this will prove to you that I do. Check it out. All you do is you take your hose, point it in the direction of the water is through, turn on the switch. You got yourself some nice running water. Keep it nice and cold. Just wash your hands. Oh yeah. You can drink, it is filtered. You just wash your face and your hair. That right there, ladies and gentlemen,
And mind you, while that was happening, I had also ordered a water pump and a sink so that I can have an actual sink with both hot and cold running water, because I was going to use a propane heater to heat it up so we could meet the definition of having both hot and running water on the inside of the pod. Not like that's required, but hello. So let's go back. The defendant publicly affirmed the religious beliefs. The defendant further asserts that requiring him to vacate the pod would substantially burden his religious exercise in violation of the free exercise clause of the First Amendment, applicable provisions in the Illinois Constitution, and the Religious Freedom Restoration Act. We've already included that on line 13 of the religious freedom in my response. That in doing so, you would violate that. On top of that, the pod is personal property. Okay, it was argued in here. So, number 14, defendant contends that plaintiff has not demonstrated that a requested injunction satisfies the applicable constitutional standards, not state, not city, not municipal, but city's own bullshit. The Constitution is not a rule. It's not a standard. It's a constitution. It's a given right automatically. I have that right. So technically, I could go back to the pod today. Legally speaking, I can't, but technically, I could go back today. and say, you know what, I'm here to practice my religious belief. And if I get arrested for that, now we're talking about a serious lawsuit. Because it's already included, and this would be entered, this exact piece of document would be entered as an exhibit in my defense criminal case if I were to be arrested for going into the house. If I went inside the pod to pray and I was arrested because I went in to, quote, use the pod, occupy the pod, and to, quote, live in the pod on property that's already registered in my name, I would be arrested unlawfully. Okay, and this would be entered. And they're going to argue and say, well, no, he defied a court order. I didn't defy a court order. That court order superseded my religious rights that are afforded to me under federal protections. Okay, so do you guys believe, in the chat, comment right now in the chat, do you guys believe that I have standing in this case? Because his response, can we get off that conversation, Taylor? That is so irrelevant to this. Okay, we're specifically talking about the motion, then we're talking about the attorney's response. We are not talking about what the pod has. We are arguing the fact that the pod is being used for religious purposes, religious freedom, religious exercise. So get off the topic about whether or not the pod has a goddamn toilet. And yes, to answer your question, it does. I can't believe you care more about a toilet than a human fucking being. For God's sakes, lady. All right. Well, I've made my point very clear. And this is where we're at. So I now have to draft a response to this response, which thankfully I've already done. So give me a second, guys. I'm going to go ahead and get that on the screen for you guys to read. Give me a second. I have to log in because this is confidential shit and I can't show it on screens. Give me 1 second. He's trying to say that we're arguing new shit when it's right here. I literally told you what the argument was about. And then I linked new findings, new evidence. It's new evidence. I'm not entering evidence. It's new supporting evidence to the claim. Okay. Oh, for the love of God. Hold on, guys. Give me 1 second. Hold on, guys. Give me a second. I need to run this by my friends because, as you guys know, this is complete bullshit. Hold on, guys. The attorney intentionally filed this case at the end of closing day. I knew he was going to do this. I wouldn't have any time to argue it. You guys, they're being so sneaky with this whole case. It's ridiculous. The hearing starts at 10 a.m. on Monday. The library starts at 10 a.m. on Monday. So even if I had adequate time, I don't have a printer. I have to go get a printer because I can't keep going to the library to print shit. Oh, for the love of fucking God. Just log in. Hold on, guys. Why am I always dealing with these? Guys, cancel your guest request because I am not adding anybody up here. You guys know better than that. I stop adding people on my live, so please, cancel your requests. Thank you. I'm not trying to be a dick today. It's just can you guys seriously get off with that whole commentary? You guys are disgusting. Seriously, grow up. Okay, so here's my argument. I can't show the screen for this because it's coming from OC, but I will go ahead and read it. Give me 1 second, guys. And this is what I have to submit. Oh, for fuck's sakes. There we go. Jesus. Where are you? I'm at a local hotel until tomorrow, guys, because it's raining outside. What else am I gonna do? I don't have a choice. This is gonna be added to the lawsuit. So for every time that I have to go here, I have to add these bills to that class action lawsuit, to a lawsuit. What the heck is he saying? All right, hold on, Gus. Hold on, guys. I'm trying to put this in here. There we go. All right, this is my response, which I have to go quickly because I got a friend of mine picking me up so I can go submit this. This is due before the end of the day because the courts close at 5. Of course, they close at 5. So we're gonna skip to where it says we're gonna ignore the first half, guys. We're gonna go right to it. Plaintiff's response incorrectly claims the defendant has not met the burden of showing a substantial burden of religious exercise. That assertion is wrong as a matter of both statute and controlling precedent. Under 42 U.S. Supreme Court 2000 CC Section A and 1, the claimant bears only the initial burden. I'm going to underline this for the judge. That a land use regulation substantially burdens religious exercise. Once that showing is made, the burden shifts entirely to the government to prove both a compelling governmental interest and that the regulation is in the least restrictive means of furthering that interest. See the following. Okay, I'm gonna just underline this fucking bullshit for the judge because she's not gonna know any of this stuff, you guys. Judges are not attorneys, so they don't know. Defendant has carried that initial burden. The record establishes the defendant's sincerely held religious belief as the Celestican Church of Jesus Christ include off-giving in a off living in a faith-based tiny home pod structure on his own property as a form of worship, self-sufficiency, and separation from church-state entanglements. Number 2, RLUIPA's definition of religious exercise is deliberately broad, which I specifically stated earlier. It includes any religion, any exercise of religion, whether or not compelled by central to a system of religious belief, and expressly covers these, the use, building, and conversion of real property for the purpose of religious exercise. 42 U.S. Code, blah, blah, blah. The statute does not require the practice to be central or compulsory. See Holt, blah, blah, blah. The preliminary injunction forces the defendant either to abandon that religious use of his property or face eviction and homelessness, currently homeless. Well, I can't say that for the argument because it won't make any sense. That is the precise type of burden the Seventh Circuit has held renders religious exercise effectively All right. Plaintiff claims that the defendant has been vague. This is the most important shit ever. Plaintiff claims that the defendant has been vague and elusive. What the fuck does that even mean? In both factually inaccurate and legally irrelevant. Okay. It's completely factually inaccurate and legally irrelevant. That sounds like an opinion, Your Honor. Defendant has identified the specific religious practice at issue, off-grid, faith-based, residential use of his own property which was submitted, and the specific effect of the injunction, forced abandonment of that use. That is more than sufficient. Courts do not require a claimant to receive every doctrinal detail or to disprove every alternative the government invents. I love that I did that in there. At the threshold stage, see World Outreach Conference Center versus City of Chicago, holding that forcing a religious organization to abandon or radically alter its planned use of property constituted a substantial burden. Booyah! Church of Lord and Savior Jesus Christ versus City of Markham. This was the fucking federal lawsuit, 18-CV, civil rights violation, -05514 of 2019, applying the same standard to individual religious land use. The fuck? Controlling precedent confirms defendant is correct. Multiple decisions confirming the defendant has been met. The substantial burden threshold. I've already met the threshold. The Liberties Union for Urban Believers v. Chicago, City of Chicago, okay, already shows that. When it bears direct, primary, and fundamental responsibility for rendering religious exercise, including the use of real property for the purpose thereof, effectively impractical. That is exactly what the injunction does here. And a fucking judge, if she cannot agree on that, please resign from your goddamn bench, because nobody in Sangamon County wants you. If you go to church this Sunday, God, I pray and hope your roof doesn't have a leak. Because if it does, you can't go to church. The World Outreach Conference Center. The court found a substantial burden where city zoning and building code enforcement prevented a religious organization which are LUIPA, you guys. It's not just for organizations, it applies to also individuals. From using property for its intended religious, residential, and ministry purposes. Beautiful. The same principles apply to an individual's faith-based residential use. This was demonstrated through the media. This was demonstrated in the photos. This was demonstrated in my response on day fucking 1 of page fucking 2. In Holt versus Hobbs, the Supreme Court rejected the government's attempt to impose a heightened showing of centrally or doctrinal compulsion. The same reasoning applies under RLUIPA's land use provisions. Can we get an amendment? Can we just get an amendment in the RLUIPA that says, hey, city of fucking Springfield, read that again. Can we get an amendment that says the city cannot use city code to burden? City cannot use city code to evict? City cannot use city code to unlawfully interfere with one's religious exercise? Because that's exactly what's happening here, people. Oh, another one, in case, that wasn't enough. In Eagle Cove Camp and Conference Center, Inc. versus the town of Woodbarrow. The very case plaintiff cites, the Seventh Circuit acknowledges that the RLUIPA protects against land use regulations that render religious exercise effectively impracticable, while simultaneously holding, like in this case, the city is saying, hey, we don't want you to be homeless, but we're going to keep you homeless, while simultaneously holding that facially neutral zoning can survive if government meets the strict scrutiny burden after the claimant has shown a substantial burden. Plaintiff cannot use Eagle Cove to erase defendant's initial showing. It only confirms that the burden has now shifted. In other words, my burden is more important than the city's burden. I have more standing in my burden because mine does not impact the public in which the government serves. I'm on private property. This is private property. Plaintiff's reliance on Cutter versus Wilkin, another one, is misplaced. Those cases address institutional accommodations and establishment clause limits. They do not alter the claimant's initial burden under the RLUI land provisions. Guys, this fucking lawyer is trying to twist existing cases that he knows the judge is not going to read, by the way, to argue my argument, my motion, and is literally using my shit word for word. This guy is so fucking dumb. And then here we go. I have to remind the judge that this is an establishment matter of law, a federal fucking law. I should literally put that, a federal fucking law, if I want to be a dick to the judge. The city has not met and cannot meet its own fucking burden. Even if the court were to accept the plaintiff's safety and zoning interest as a compelling, which the defendant does not concede, the city has offered no evidence. There is no fucking evidence that my tiny house is going to impact the public. So yeah, I think I've made myself very fucking clear. Give me a second, guys. Got to make sure the case number is correct, because I got to run down there. Yep. Save. More options. Browse. Thank you for the follow, guys. I gotta run downstairs. My friend's here. I'm gonna go and file this ASAP. Response to response. Give me a second, guys. I gotta upload this. Craziest fucking shit, bro. By the way, I got this email right before closing day, so I got a little bit lucky there, but he did this shit on purpose, and I knew he was going to file this at the end of the week. I fucking knew he was going to send this to me and file it at the end of the week. And you know what I think is funny? I can't fucking e-file to fucking save my life. They blocked me from e-filing. Explain that to me, guys. Keys. In case something gets fucked up, I gotta grab my computer chat. It's super fucked up. It's super fucked up. Like, it's super fucked up that he's trying to say I haven't met my burden. Yes, I fucking have. It's right there. Complete crap. Hold on, guys. I'm gonna pause real quick. I'm gonna resume. You see how he sent this shit at the last fucking minute, bro?
I was just watching it on the way here.
They're literally fucking with me because they're like, they know I don't have, they knew I didn't have a computer, I had to get one. And then they knew I didn't have a printer, I don't have one, so I have to actually go figure that out. But I'm not gonna get a printer, bro, if I don't have anywhere to put it. That makes no freaking sense. And then the judge intentionally scheduled the hearing so that it was exactly at 10 instead of 10:30 like it was at first.
Oh, because the library opens.
The library opens at literally 10.
They don't want you to win.
They don't want me to win at all. They don't want me to argue this case.
It's because they know you have a
Because-
possibility with the religious.
Right.
too.
Can
Yeah.
you hold on for a second? So this is why. Because if I win this case, everybody all over the state of Illinois can use my case to build. I don't even have to file for the PODS Act. Because it would hold in court. It'll literally hold in court. That means if you buy a vacant land and you build a pod on it, they can't do shit. They cannot do shit if I win this case. That's why this is so important. They are doing everything they can to make sure I don't win so that they can't let anybody do this. Because their sister company, CWLP, would lose money. They would lose money for not having utilities. And they don't want people to do what I'm doing because by the way, the property prices for vacant lots if I win are gonna go fucking high. Because everyone's gonna want vacant property in Illinois. Okay? If you have vacant land right now and you buy a piece of land that's like $3,000, if I win this case, it's gonna go like 50 grand. The lot next to me just sold 50 grand already. 57,000. I'll show you guys when we get back. So they know that if I win this case, the property taxes go up. The property value goes up, but there's no property taxes. Because there's no way to tax a dwelling that's not on a foundation. And they know this shit. So they're doing everything to shut me up. They've tried everything to shut me up, to kick me out, to defame me. They're doing everything they can. So, and the judge is in on it. It's really disgusting that the judge is in on it.
So that judge knows.
So I'm not going to hold my breath in court Monday. I'm literally going to tell her straight up, you need to resign. I just brought before you 5 proven cases. 5 cases that are strictly from the state of Illinois. I didn't go anywhere else. I brought 5 proven cases from the state of Illinois that literally prove live. Hope you win. Thank you yet. Sorry, I'm like super, like, I'm not trying to be
it's
like.
It's a frustrating position, man. You're completely fine. We're almost there. Maybe 1 minute away.
Because, guys, I have nowhere. The amount of fucking energy, stress, and time that this has caused me is insane. The judge is involved because the county gets paid on property taxes. They share the water with the city. CWLP also provides water for Sangamon County residents. This is way beyond the pod, you guys. If you guys don't see how all this totaled out, watch the hearing, watch the video. My evidence supports my claims, and I've already shown the burden of proof. I've already shown it. And I'm not even required to show it. The burden has shifted. In this situation, my burden supersedes the city's. And I've already shown it. What's the reason you didn't want city water? Go look at their publication on their website. I'll show it to you guys when we get back. They've already admitted they have a 21-year lead poisoning problem in the city. They have to replace your pipes with federal issued grants and money, which we paid for. Okay, The Illinois Environmental Protection Agency has paid Springfield tons of money to replace their shit. This is a man-made lake. They made this shit. They bought property, they dug the wells, they made their own lake, and now we're giving them our fucking taxes? We're just giving them our fucking tax money because they can't get their shit together, and then they're forcing us to drink their water, and if we don't buy it, they shut us down? Are you fucking serious? Yeah, I didn't think so.
You can go in right now if you want to.
I have to go right here.
I'm gonna go park over here.
Park right here, because when I get out, I'll be right here.
Okay, are you sure I can park?
Yeah, you're good. I'm gonna knock this out. I should have a couple quarters on me to pay for the print, and then I can go file it ASAP. Yep, I got it. Okay, be right back. I don't think I'm gonna need the computer, but just hold on that for a sec.
You should just put it on the back. Just in case.
No, because I just want to get it in out. I want to print. I literally am just gonna log into the computer, log into my drive, print the paperwork, and be done. Be right out. Then we gotta go file. I gotta go e-file. Then I gotta go and let the attorney know I've e-filed. Now he's gonna have adequate time to review my argument, and then he's gonna argue that argument in court. So he's arguing my existing motion, which is an argument. Then I'm countering his argument. Then he's gonna write up another argument in court, which I won't even have time to review. I know how this is gonna go. He's gonna respond to my response from his response to the motion I filed over the weekend. And there's gonna be, and I know the judge is gonna say, oh, well, since he responded to your motion with another response and you haven't had time to view it, I guess I'll enter a continuum today. Watch her try that shit. If she enters a continuum for this response on Monday, the order will still be the same. It'll still be the same. Which means there's gonna be another court date. It'll probably be like 30 days out, and then I won't be able to have an argument in court on Monday. It'll be a waste of everybody's time. Hey, can I use the computer real quick?
Sure, just to let you know there's only about 30 minutes left.
I'm printing and I'll be right out. All right, chat. I'll file an affidavit on Monday. I'll write up an affidavit and I'll file it on Monday. And that'll act as evidence. Which is pretty smart, Instapoo. I didn't even think about that yet. I'm not gonna e-file on my own. I'm gonna go to the courthouse. Okay. DM me, okay? DM me and I'll look into that class. Thank you, chat. Appreciate it. 14 two-page black and white. And there you go. It's 20 cents a sheet. Explain this to me. This is a public library. They acquired public funds to purchase their printers, and we're paying for the material. Pass the buck, huh? I gotta make sure the case number is the same. No, you're good. You can keep it. I should have underlined everything, but it's okay. I'll do it later. I think maybe that's the problem. Maybe I'm making it too easy for the attorney because I keep underlining my arguments. And I think what he's doing is he's taking the arguments and finding the clauses for them. So that's what I think is happening. So I'm gonna stop giving him my cheat sheet and give him a plain sheet like this. I'm basically letting him cheat. Courthouse. Sweet. Appreciate it. And then you're good on you're good on fuel.
Yeah, my dad. Well, I already filled it up.
He already filled it?
No.
You didn't?
It's like
oh no, I got you. I'll fill it.
Jeez, man, on missions.
This is how it's like.
Appreciate it.
You have no idea the shit I got.
I get to do these things for. I like doing things.
Well, you're doing it for a difference. Like this is a huge deal. And let me put it to you this way. Chat. Him driving me here could have a significant effect on the case, but we got to get there and file this ASAP because I don't know who's in line. It's gonna be over there.
Oh shit!
Yeah, it's Sangamon County Courthouse. You just make a right. It's all good. Make another right. You know that the federal building is here, right?
No.
That's where I went to go file. That's where I went to go file the lawsuit.
Another courthouse, but I've never really been there.
And you don't want to. They recognize me right away. They're like, Colton? I'm like, yes.
Oh
they go,
goodness.
Bro, long time no see. I was like, yes, I know.
I go straight.
Yeah, go straight. You're gonna want to stay on the middle for right now.
Oh, okay.
So you gotta figure out which side it is on.
I think it's down there, right? You're going to the courthouse.
Where are you staying tonight? I'm going to the Sangamon, the courthouse.
Oh, okay.
The courthouse. Not the U.S. District Courthouse. The actual courthouse, Sangamon County.
Yeah, just leave me there. Honestly, I don't know where it's at.
I'm staying at a local hotel, guys, until tomorrow. I have to check out at 11. It's because of the rain. I asked the attorney to put a pause on the preliminary injunction or to seek relief for 3 days. And they said, nope. Showing that it was going to rain, and they still said, nope, we don't care. Thanks. So now what he doesn't know is when I go to federal court, I'm going to say he was aware of the burden and the hardship before these events took place. It's on 9th Street and Monroe Capitol. Okay, so I think we just passed it.
I thought it was that way. That's what I guess.
Here, just put it. You want to put it in your phone so you don't keep missing it?
It's just my phone is also low. Hold on.
Oh,
What is it
dude.
called?
It's just Sangamon County Courthouse. That's got to be it up there.
Oh, that one right there?
Yeah, I think. Oh, wait. It's on like 9th Street. I don't have my glasses on, so I can't see shit, but I know it's like here. Guys, chat, what's that? Let me get the address. You need the address?
Wait, is it this Sangamon County Court Service?
Circuit Court, yeah. Why is it saying closed? Click on it.
No, it says closing soon. This one's court.
Okay,
court
go.
County Circuit.
Yeah, just go there.
Okay. Yeah, it's right.
It's right across from the fire. Oh, it is. Okay. Guys, I'm still trying to learn this area. I don't really know where everything is at.
I lived here all my life.
Now, imagine for somebody that doesn't have transportation, doesn't have an attorney, doesn't have a computer, doesn't have a printer, doesn't have a place to stay tonight, trying to do all this shit. Like, do you guys know how insane this case is? The parking lot across the way charges though. He'll just drop me off and then I'll have him wait local somewhere. If you can't park.
I'll probably
Just put
sit
your
right
hazards.
here.
Yeah. Is that it right there, the courthouse?
I believe it's this right here. I'm not sure it says.
Is that it? I can usually tell by the staircase. Just stay on this side. I think that's it. Yeah, that's it.
Alrighty.
Yep, that's it. Just park and put your hazard down. Might be easier that way. Or better
Or
yet,
just set
go
off
in,
right
go in
here.
there. There might even be parking in there. Or
I'll
just sit.
Yeah, I'll just let you out right here, and then I'll
Okay.
pull up in there.
Sweet.
Alright.
All right, guys.
Get you in there.
Okay. We're back. Have that same attitude when it's your kids trying to cross your fucking highway. Jesus Christ, this black truck almost just ran me over. Have that same attitude when it's your kids. Hey guys. Oh, you don't need that. I'm live streaming. Give me a second. Belts?
You can go through.
Okay. All right, go ahead. Go on through. I just have a regular one. Okay, you're good. You're good. And I'm going to file. I'm just going to filing.
Going to what?
Filing?
Okay. Is it family, civil, or criminal?
It's fourth. I know where I'm going. I just want to tell you that.
Oh, yeah, I
In case,
appreciate it.
You know, yes.
Thank you.
Yeah, you guys had to go through security. It's okay. They've seen me here like a million times, so they know who I am. Mostly people are supposed to take their belts off, but, you know, whatever. Not from the courthouse. Not from the courthouse. The municipal building. The municipal building and the police department. Not the courthouse, you guys. I can't be banned from the courthouse by the city because the city doesn't own the courthouse. The city owns the municipal building, not the courthouse. The courthouse is owned by the county, not the city. You can't ban me from a county courthouse. They don't have jurisdiction to do that. Only a judge could do that. Only a court admin can do that, but they wouldn't. They get sued for that. They wouldn't be able to do that. Okay. How are you locking your door? Hi.
We're closed.
You don't.
Yeah, we're closed, my man.
I have to e-file. There's a court here.
Coming Monday at 8 o'clock, 8:30. Sorry.
No, because he needs to have time to respond to this case.
We do understand that, but we close at 4:30.
Are you a manager?
Sorry?
Are you a manager?
I'm not a manager, but we
We
do
are
work
closed.
with.
The building closes at 5 and you're closed at
We close
4:30.
at 4:30
There's
here in
signs
the
out there that
circuit
say
clerk's
their office
office.
closes at 4:30. Okay.
Okay, well, let me talk to a manager because this is not right. This isn't right.
Yeah, we're closed. We're locked up and closed.
I need to e-file. I'm here to e-file a response.
That was, our computer went off before us.
So you're closed at 4:30. The building closes at 5 and your computer closes at 4?
Yeah, because we have lots of people we're finishing up with.
Okay, well, this is an e-file. I'm here to e-file.
You can e-file from the library.
No, I can't because I don't have access to the account.
Gotta be here before.
Are you a manager? Can I talk to a manager?
She's an assistant
Every one
manager.
of the computers is turned off. at
Let
the
me
end of the
talk to a
month.
manager because this isn't
I
right.
am a manager.
You're an assistant manager. Let me talk to a manager.
She'll tell you the same thing.
Then let her tell me the same thing.
You brother.
Yeah.
After 4:30 and after.
I'm still gonna be here next week for 3 days.
Have a great weekend. Have a great weekend. Have a great weekend.
You too.
It's nice to know you guys get to leave early. Half an hour early to be exact.
We leave at 4:30.
Yeah, the building closes at 5.
We don't. Hi.
It's literally 5 on the listing, but okay. Can I talk to a manager? Somebody that's working? No? Alright. Unbelievable. They closed at 4:30. It's 4 fucking 30, and all these fucking bastards can't even do their fucking job. It's 4:32. I got here right at 4:30. Give me a break. So no. Let's get their faces on camera. You want to say your name? You work for the public. You don't want to say your name? You don't work for the public? Oh, hold on, guys. We're all going in the same elevator, so here we go. You're not here to serve the public? You just want to go home? Yep, I thought so. I have no interest in going in the same elevator as them. I really don't. That's just disgusting. That's just flat out disgusting. Seriously. By the way, this case is because I got evicted from my home. So go home.
This is a really good one.
Supreme Court.
Hi, guys. Care to explain why the building closes at 5 and you guys are leaving at 4:30?
Well, our office closes at
4:30.
4:30.
Oh.
But there are other parts of the building that are still open.
Yeah. I got here right at 4:30.
You can't e-file past
Yeah,
4 o'clock
4:15
anyway.
Mm.
You need to be here by 3:30 to e-file.
And is that like a rule that you guys made up, or?
Yes.
Oh,
No,
it's a made up rule. Okay. It sounds pretty made up to me. If a courthouse doesn't close until 5, why would your e-filing close an hour before? It's e-filed.
I mean, you can still e-file after.
Can you file from your home?
Oh, right, that's right. I can't go home because your judge has evicted me unlawfully from my
Our
home.
judge.
Not your judge.
We all cram in here.
Oh, so it looks like there are others leaving at 4:30.
Yep, other offices close at 4:30.
So the building closes at 5 and you guys close at 4:30.
Yes, apparently.
Interesting.
Hopefully there's not too many of us in here.
The only person not going home today is me, guys.
Okay.
Because quite literally, I have nowhere to go. I'm not trying to be a dick, but it's the truth. It's literally the truth. It's just hysterical. They don't care to do their jobs at all. It's 4:30 and they're already packed up to go. It's amazing how fast that happened. Well, guys, I couldn't file my e-filing today. You may want to tell people who come here at 4:30 that the reason they can't file is because their computer e-filing system is shut down at 4, even though the building is closed at 5. Nobody does, because it's a made-up rule. So let's thank these 2 officers for at least being here while the rest of these cowards are going home. So thank you, guys. Can I get your name? Ryan, and you are? Thank you, guys. At least somebody's here doing their fucking jobs. So, see you guys. Unbelievable. Unfucking believable. So now, the attorney is gonna say that he hasn't had time to review my responses and that he's gonna need additional time to review them. Which means there's going to be a continuum. Which means there's going to be a continuous, guys. Who the fuck? You can't e-file past 4 o'clock. It's e-filing. That makes absolutely no sense. It's e-filing. I can't e-file because I'm locked out of my account. They locked my account so I couldn't e-file. That's why I came here to rush here. It makes no sense. And they close at 4:30. I got here at 4:30. A manager could have submitted it. All right.
Deadass, I'm sorry, man.
I can't keep up with my case, you guys. This is not harassment, Carrie. It is me trying to submit my case paperwork. Lord have motherfucking mercy. They could have easily have helped submit this. This is evidence of literally neglect. I literally went in there to say I'm looking to file this, and I asked to speak to a manager who could have easily helped me file this. I didn't wait till 4:30. My friend couldn't get here until at the earliest convenience. We literally rushed to file this before 5. We were under the impression they were closing at 5, not under the impression they were closing at 4:30. I didn't know they were closing at 4:30 until we got here.
And the building said till 5.
And the building said till 5.
Listen, guys, too, y'all gotta understand, this is a frustrating moment.
Of Quite
Like,
literally,
it's-
like,
it-
no,
you
ignore
gotta
the chat.
understand.
Ignore the chat. They're literally just, they're so,
It's just you
they're
have
so
to be in the
immature. It's like,
position
we
to
literally
understand.
went in there. You guys don't understand the severity of this.
Sucks.
It has nothing to do. It literally says 5 on Google. says 5 on Google.
It's crazy.
Yo.
I just pulled up the.
Y'all would be acting the same way, trust me. Don't even try that shit. Y'all would be acting the same way. I literally asked if a manager could literally do it. And they were like, nope. And then they said that their e-filing closes at 4. Does Google say their e-filing closes at 4? Like, hello? The fuck? What time did I call you to ask you to come pick me up? It was 1:30.
Yeah, and I had that
It was
stuff
1:30. I have text messages to prove it. I literally asked my friend to come grab me at 1:30. He had to go run some errands, and he came to go grab me to go fill this out. I got the email at 1:30. Didn't I call you right away?
That's right. Whenever. Yes.
I literally called him as soon as I got the email and said, I have to file my response.
Literally, he was saying stuff about streaming and all of that, and then they just fucking surprised him out of nowhere with the response. Late as shit, by the way. And then now also
The response came late
Monday
because it was
when the
filed.
court is.
My paperwork was filed Monday. The attorney replied today. I only had a couple hours to do research on it, print it out, and file it. So how are you guys saying, oh, that's laziness? Bro, when I got served the fucking paperwork, I didn't even have time to review the case. It was literally the next day. The hearing was scheduled the next day. So you all are saying I'm lazy. I have literally done all this shit on my own without any help from anybody. Okay? Thankfully, I've got a friend over here who's willing to give me a ride. All they had to do was take the paperwork in my hands and file it. That's it. It would have taken them no more than 2 minutes. When they were finished walking out that door, it was 4:32. It could have been done by then. So you all are sitting here saying all this shit about me. Go ahead. Public transportation? Yeah, from what?
Public transportation. I offered him help.
Literally, my friend is literally offering help.
I like helping people. That's what I like to
So,
do. And I've seen this man on my
He
social
made
media.
an effort. I made an effort. We came down here. We were under the impression we had time, but we anyways early, and this is what they're saying. So you can't sit there and argue that, guys. Like, just shut up already. Just shut up. Everyone thinks they're right until you obviously gotta go through it to learn. I'm not an attorney. I don't sit here filing shit every day. I got other things to focus on. Oh my fucking God. You are all so fucking stupid. I should have gotten there before they closed. I did get there before they closed. I literally got there a half hour before they closed. Then they told me they closed. Hello? Yo, are you fucking kidding me right now?
I ain't gonna lie, they're just rage baiting.
No, I know they're rage baiting, but it's like, it's just funny. It's like you literally just said what I just said. I got there before they fucking closed. Give me a fucking break. And by the way, they know what this case is about. So it's not like they don't know what this is about. So now I can't say that I have to rewrite this. I have to reprint this and I have to rewrite this. But guess what? That won't happen because I don't have a printer and I can't print. Because this says on the second page that I duly swear I've served this on this day. But if it's not filed, it doesn't matter. It makes no sense. Always go to these places in the morning. Guys, I literally fucking got this at 1:30. I literally fucking got this at 1:30. And I asked my friend to come pick me up so we can go over there and fucking file it. What the fuck do you mean? Bro, they are... I can't. I can't with the stupidity in the chat right now. I really can't. People have no clue what the hell I'm going through. They have no clue. I'm supposed to be on time. So 3 hours. Oh my fuck. You didn't hear a shit. You didn't hear a damn thing I said, so it's okay. I'm not going to repeat myself. I'm not.
You're supposed to. Everyone just look at the video that he's going to post. He's going to explain.
Like they've never been late for work a day in their life, right? Yeah, like that's happened. It's fucking hilarious. I literally said I was waiting for my friend to get here to come pick me up. It had to be at his convenience. So, it's alright. And why are things always against my favor when I make a goodwill attempt to get something done? I literally fucking went down there a half hour before closure. I rushed to get to the library to print out the paperwork because I don't have a fucking printer. Now, had I skipped the library part and just had the paper in hand, yeah, I probably would have been able to e-file today. But still, it would have been too late. It was too late by the time we left because according to them, e-filing was at fucking 4 o'clock, an hour before closure. It's e-filing, bro. You wouldn't got to do shit. And don't you think I would have done it online if I had access? It is what it is. No, it's just the retarded ass fucking comments in this chat. I'm so sick of it.